So I'd just like to introduce myself before I start. And my name is Patricia Hughes. I'm the Executive Director of the Law Commission of Ontario. We are actually located down the hall in this building. And we were created in 2007 to look at the law and make recommendations for reform of the law in various ways. So we've now produced 6, 7, 8 reports. We'll be releasing a new one next week if you have nothing to do on April the 3rd. April the 3rd, we're releasing our Vulnerable Workers Project. We've got a family one coming out later in the summer. And we've released reports on older adults, disabilities, Provincial Offences Act, division of pensions on marital breakdown, and other kinds of reports. We've done one with the Ontario Women's Directorate on violence against women, preparing modules for teaching about violence against women in law schools. Not violence against women in law schools, but teaching about modules. Developing modules for teaching in law schools about violence against women. So quite a variety of different kinds of work. I don't know how many of you are familiar with the work of the Law Commission of Ontario. Some of you may have touched on it in some of your courses or whatever. Anybody familiar with it? Oh, that is sad. You are?
Yes, it was in a number of our textbooks. We'll have excerpts from the Law Commission reports.
Okay, that's great. Okay. So that commission was created in 1964. It was the first commission created, really, a modern commission in the British Commonwealth. And it lasted till 1996 when its funding was cut. So I won't talk that much more about it, but one of the things I want to talk about briefly with the commission is how we do our work, because it is somewhat related to what I'm going to talk about today, and then I'll go into this particular talk. But one of the things that's really important to how we do our work, two things. We set up advisory groups, and on advisory groups we try to have representatives of people who are affected by whatever it is we're studying. They vary a lot from group to group because it depends on what it is we're studying, but in many cases we have members of community groups. Mostly people have something to do with the law, but not always. And the other major aspect of our work is our consultation process. We do quite extensive proactive consultations in the sense that we go out and do those consultations, and we don't wait for people to send in submissions to us. Of course, we take submissions, and we do that in ways that we hope make it easier for people to send them in. But we also get out there. For our disability project, for example, we held 17 focus groups across the province. And some of those focus groups were comprised of people with disabilities. We had a group that was particularly looking at the impact of race and disability. We talked to Aboriginal elders, and there were several other sorts of connections like that. So that's something that's really important to us. And in our analysis and then our recommendations, we try very hard to keep that kind of theme, where we're looking at and learning about the impact of law on the people who actually are affected by it, and then involving them in our work and considering them in our analysis and taking them into account in our projects. So this Vulnerable Workers Project that we are releasing the final report in next week is about vulnerable workers in general, and that means people who are in contract work, part-time work, and so on. And this is a big topic these days, migrant workers. But we're focused on women and on racialized groups, recent immigrants, and the impact of that kind of work for people. What happens to them during their lifetime if they do that for most of their lives? What's the effect later in life, that kind of thing. So that has been an important part of that particular project. It really is a focus of that project. And there are some people here from, and they were not urged by me to come, I suggested not, but here they are. So these are some of the people who are actually working at the Law Commission. Anyone who's interested, be happy to talk to you. They'd be happy to talk to you, I'm sure. I should tell you anyway that we do hire students while I have a chance to make this plug. We hire students in the summer and we hire students during the academic term, graduate students and undergraduate students in law. So that may be of interest. So I'll introduce them first. So Sue Grattan, who is working on a project that is quite different from the projects I've talked about so far. It's on Forestry Workers Lien for Wages Act. So those of you who have a very sort of legal, positivist approach to law might appreciate that project. Noreen Nathanson, who is our Ministry of the Attorney General Counsel in Residence, has actually been the one who's now responsible for the Vulnerable Workers Project, and so she's going to speak next week at the release and talk about it. And then Sarah Mason Case, who is a research lawyer with the Commission now. So let me start the paper. Now, I'm happy to take questions as I'm going along. If you have anything you want clarified, although Jody will have to jump up and run over, so I guess it's easier to do it at the end. Okay, so I will talk for what? No more than 45 minutes. So the paper, some of you may have looked at the paper, but, and I'm sorry if some of you have looked at it, I'm going to repeat some of what's there, but this paper is actually a draft or a short form of a paper that I'm preparing for a summit that the Canadian Bar Association is organizing for the end of April. And the summit is called Envisioning Equal Justice Summit. And they're looking at what it is about the legal system that poses the kinds of problems that so many people face. And often this is focused on unrepresented litigants, for example, but it isn't always unrepresented litigants who face some of these difficulties. So that's part of what they're going to talk about. They're going to talk about issues such as pro bono help and legal aid help. When is it appropriate to have legal aid and when is it appropriate to use pro bono services? Are they interchangeable? That kind of questions. So they're talking about that. But it's a fairly broad summit, and there's been a number of papers prepared for that, or being prepared for that. So I'll be delivering my paper as part of the opening plenary session. And it's kind of a setting the stage kind of paper. And what I want to talk about and set the stage for the rest of the discussions in the summit of that day, the couple of days that we're doing it, is to think about the need for inclusivity in the legal system. And it's not a new idea, but we talk about it, but we don't really pay attention to the impact as much as we've reached the point, I think, where we start making assumptions. We don't really know exactly what that means. We don't really know often what effect certain characteristics or circumstances have on people's interaction with the legal system. And we don't really know how to measure it. So one of the things I'm trying to do with this paper, and as everybody says when they give papers, this is in preliminary stages, so you can be as critical as you want, because one of the things I really would like to get from this is some comments that will help me finish off the paper for the summit. So I want to look at how you measure this kind of issue, inclusivity. And I'm going to talk a bit about what are the ramifications of inclusivity for how you deliver legal services. So does it make a difference whether or not you're using legal aid or pro bono services for people who have low literacy skills? Does it make a difference depending on their place of geographic residence? Does it make a difference for people who live in Aboriginal communities? And you can go down the list, obviously. Now, for the summit paper, I focused on 4 different kinds of characteristics. And of course, there's a lot more, and I talk in the paper about some of the others, but I can't talk about all of them, so I focused on 4 of them, and there's an overlap, obviously. So in the paper, I'm focused on Aboriginal status or Aboriginality, disability, literacy skills, and geographic residence. But I thought that for this paper, I would actually talk a bit more about literacy skills and geographic residence, because they're the kinds of issues that don't get raised quite as often. And some of the assumptions we make about how we can include people in the legal system actually don't work for people with low literacy skills or who live in Northern Ontario or live in rural areas. So again, there's going to be an overlap with some of the other characteristics, and we can talk about some of the other characteristics if you like afterwards. So I'm going to talk about what I mean by diversity and inclusivity. I'm going to talk about what I mean by access to justice, giving some examples of diverse needs and what's required for inclusion, and then how can we measure access to justice and the ramifications of those measures. How do we use them? So first of all, I start with this presumption that everybody is different in some way. Okay? So it's not a question of thinking about a norm, if we're thinking about the ought as opposed to the is, that we shouldn't be thinking that there is a way to be and everybody else is somehow different from that and therefore needs some form of accommodation. But in fact, we all have something that makes us identifiable in some way, in broad terms, whether it's race, whether it is gender identity or sexuality, whether it's disability, whether it's whatever. And that just about everybody fits in, if you like, to some kind of category, but usually to more than one category. So people actually live their lives with their identities flowing from one to the other, depending on what it is they're doing. It's actually quite difficult to capture that when you're talking about these sorts of issues. So you have to try to work with that the best you can, but you have to at least start with that assumption. So the goal really is to design a system, and it's not easy to do, design a system that assumes that that's the case, and therefore the system responds as a norm to the different needs people have. Even then, you might have to make some particular accommodations for people who don't quite as easily fit into that process. For whom setting up the system in general terms is just not feasible. And you may run into some issues around disability for that reason. But as we go through, we realize more and more that much of what we do, thinking about one kind of characteristic, actually has enormous implications for other people as well. And so you find overall that the differences aren't as great in terms of need, that is, that the differences in need are not as great as they may have seemed, and that one thing might help another. And the most common example, obviously, when there's a response to a particular characteristic is the curbs that we have on sidewalks. So when we first set up those curbs, that was to help people who were in wheelchairs, basically. But I don't know how many of you use those curbs, those ramp curbs. I know I often do, unless it's a little inconvenient to walk that far. But certainly people with baby carriages, older adults, and so forth use those as well. So that's a simple example of how something that was set up to respond to a particular challenge actually is extremely helpful and has become a normal thing for us to do. Okay? So if we think about everything that way, we find that it's much easier to consider that when you design a system, you design it with that end goal in mind. How helpful can this be to everyone? And when you cannot do it for everyone, then you have to do it very specifically. Having said all that, of course, some forms of diversity have played a greater role in setting up the system as it exists now. I think one of the things that's really important, though, is to appreciate how different the system is from even what it was about 10 years ago. So we're really building on some of the things that have been done. So at one time, for example, the legal system really, let's say in court, didn't take into account what people with disabilities might need. And disability is actually a very difficult one because it's, first of all, there's so many forms of disability, and severity of disability makes a huge difference in the extent to which one can participate in the system. So at one time, there would be no recognition of any kind of disability. Increasingly there is, and of course in Ontario it's required, and the courts have in fact developed a plan to respond to the needs of persons living with disabilities, and that process is going on. We have recognized in the courts that there need to be translators, but this has not been a very good response so far. So the principle of needing translators, given the vast changes in our population and the recognition that people who come from other countries and might not have easy facility in English or in French, might need a translator. That recognition is there, but here's a case where the implementation is not that good yet. There's still a question of how competent interpreters are, making sure that interpreters have been recognized, having a system for doing that, certifying interpreters and so on. So we can go on and look at all kinds of other issues, but those are just a couple of examples of how, if you looked at the system 15, 20 years ago in particular, you would not see that as readily recognized. So there has been a much greater refashioning of the system to reflect different kinds of diversity. And so the model that we need to develop has to be a system that is sufficiently inclusive that, if you like, difference is the norm. That's what defines norm, is that there is a wide variety of difference. And what I've said so far suggests that in some ways what follows from the difference, if you like, is actually more important than the difference itself, as far as we're looking at redesigning the system. And I don't want to make too much of that, but really what we're trying to see is what are the challenges people face when the system has not been designed with them in mind? What challenges need to be addressed? And it's the challenges, it's the response to the challenges that we really want to focus on. Okay, so that allows us then to link common requirements from all those different challenges, or to make common requirements, but crucial not to lose sight of where we need very distinctive responses. The trick then is not to submerge difference in the norm, but to define the norm by reference to it as much as possible. So I'll give you an example of how that can happen. As somebody who has been a feminist for pretty much most of her life, since I was about, well, I was in high school, so that's a long time. I can remember we didn't use that, well, yeah, second wave of feminism. It becomes very tempting to say, let's not talk about that so much anymore as humanism or inclusiveness, and I'm running that risk here. But what you worry about is losing what has been gained or losing what is required to be addressed when you use these generic terms. So it's a real challenge to keep that in mind, and I still think in some ways we have to think about it that way, but in others we can't lose sight of those differences. So that's an example of where that has been a constant issue in feminism, but I think also true of some of the other kinds of approaches that we take. So by diversity then, and the other side of that is inclusivity, I mean cultural, religious identity, and ethnicity, sex or gender, sexual orientation, sexual identity, aboriginality, race, disability, age, geographic reference, literacy, and the first time I've mentioned this in relation to the legal system, economic status, which of course, when we look at it carefully, turns out to cut across pretty well most of these other characteristics as far as the legal system is concerned. You might include other characteristics, and some other jurisdictions have when they've explored these kinds of questions, such as living in institutions, whether you're looking at prisoners, psychiatric patients who live in psychiatric institutions, homelessness, people who don't live in any institution whatsoever or any home, and others. And I refer to a study, in the paper I refer to a study in New South Wales that has a long list of characteristics. And as I said before, but to re-emphasize this, that there has to be a recognition of overlapping or intersecting identities. So, obvious ones, and you'll think of lots of others. Geographic location and living in an Aboriginal community. So we look at geographic location in the north, it affects everybody living in the north, what I'm going to talk about, but it very much affects persons living in Aboriginal communities. Sex and cultural or religious identity, and the impact that combination has on how the legal system might be addressing those issues. So, for example, that big question that we've got about wearing a niqab as a witness. So that question raises issues both about sex or gender and about religious belief or cultural identity. So these kinds of things have a major impact there. Disability and low income, and we could talk about Aboriginality and low income. A major combination, since there's a highly disproportionate number of persons with disabilities and particular kinds of disabilities and low income. And then there's a lot more complex relationships. So, as I say, I'm going to concentrate on literacy and geographic location just for the sake of being able to give a bit more detail than if I tried to talk about everything. First thing about literacy is that it is different from language. It's different from facility in language or capacity in language, and that's important because it can look the same to people. But you cannot assume somebody who has difficulty, say, in speaking English and has difficulty understanding or being made themselves understood, actually doesn't have a high degree of literacy in their own language. Now, to some extent, it plays out in similar ways because of the difficulty of reading materials or whatever, but there's a definite difference in those phenomena. So what is literacy? What is the relevance of literacy? It's obvious in the sense that in the legal system, there are, first of all, so many materials you have to be able to read. And it doesn't matter whether you read them in a pamphlet or you read them on the web. It's still reading. Okay, a lot of people can read that. The second level is understanding them. And we immediately lose quite a few people when you talk about understanding materials, whether, again, it's print or on the web. And that's particularly true of legal materials. And in looking at legal materials where people have tried to put them in plain language, it's pretty tough to put legal materials in plain language if you try to do it. You can start off with some pretty plain language, but the more you get into it, the harder it is to avoid, even if you're trying to avoid jargon, avoiding the complexity. So that's the second level. Now the third level that you need in order to use written materials, and for self-help in particular, is applying the materials. So people may read them, they may understand them, basically, but then they have to apply them to their own circumstances, and that is an added layer of understanding. And that then becomes quite an issue, actually, in Canada, the number of people who can do that. So 20% of Ontarians have a level 1 capacity, literacy. That is 20% of people can only operate at that level, that is to say, reading alone. 25% can go the next level to having some understanding of the material, although again, this isn't necessarily complex material. So there's 25% of people who don't go further to level 3, or higher, I should really say that. And levels of literacy differ among different populations. So 60% of recent and established immigrants and 37% of Canadian-born population are at levels 1 and 2. And the largest proportion of people over 65 have difficulty at level 3, actually. That's something that, there's a couple of things there. One is the question of whether or not there's a mix-up on immigration and an actual understanding of the language. The studies suggest not, that they take that into account. But the question of age is one that eventually will be taken care of in many ways. So when you're looking at people over 65, over 70, over 75 now, you're looking at people whose education levels were not as high. And we're not dealing with the kind of material that they may be looking at now. So that's going to change. The other group that has very low literacy levels, and that again is understanding and applying and so forth, are people with intellectual disabilities or cognitive disabilities. So that's something that is not likely to change because that's almost part of the definition of the disability. So you're always going to have some people with low literacy skills. So what are the implications of that? And I talk about that a bit more in the paper itself. So print information is not really accessible for those people. As I say, language level and the complexity of legal language makes understanding information difficult, and even more difficult to apply if you're supposed to apply it yourself. Filling in forms is a real problem. Carrying out instructions is difficult. I don't know how many of you, and people operate in different ways, right? I mean, some of us have to see something in writing before we can really get what it's about. Some people, you know, can be told something and go ahead and carry it out. Most people, in fact, let's say somebody with low literacy actually ends up with a lawyer, a legal aid lawyer. So the legal aid lawyer explains what is necessary. The reality is that it's very difficult for people to go out of that setting if they have a low literacy skills, and do what they're supposed to do. And studies have shown that you cannot easily carry what you've been told and use it later, even if it looks as if you're understanding it when you're told. So that's very difficult. People with low literacy levels tend to feel very uncomfortable in situations where it's assumed they have certain levels of literacy, whether it's in a courtroom or whatever. So judges, for example, have been learning how to recognize people with low literacy. They may come into the courtroom on their own, they're self-represented, and it turns out they've forgotten their glasses, so they can't read anything. It turns out they forgot the forms at home, when of course they couldn't fill them in. And there's all kinds of other signs for people. So people are starting to see this and realize there needs to be further help. So you know, it's a particular form of disadvantage that is made worse by the fact people don't want to admit it. It's been talked about a lot more. There's been more effort to deal with adults with low literacy, but nevertheless, it's still a problem. The increasing reliance on technology to communicate the law and to provide information on the assumption that this helps self-represented litigants, something that I think is in fact questionable. But in any event, it's not going to help people who can't read. It's not going to help people who can't then apply the information. And that's a lot of unrepresented litigants, by the way, and not only people with low literacy rates. And this is, again, exacerbated by low income. And inevitably, although not everybody with low literacy skills has a low income, people develop amazing coping skills and ways of hiding this and are able to function quite well in some circumstances. Nevertheless, there is a big overlap. Low income and therefore not being able to afford legal services very easily. So what needs to be done? Now, to some extent, technology can help with this, and there have been some very sophisticated technology developments in the United States, for example, where there's a lot of audio, a lot of visual, taking people through, but it's not complete, but it does help somewhat. I talked about, for example, judges and, of course, others who are learning to recognize the cues, so training of people to recognize the cues. But ultimately, it requires in-person support. Here's a place where for people to function in the legal system in an adequate way, need in-person support. So in the future, this will diminish somewhat because some of it's related to education, but not all of it. So some of these responses will still be needed. So that's literacy skills. And I think what's amazing about that is the extent to which we underestimate the degree to which that is a problem. Geographic location. So what are we talking about here? We're talking about people who live in rural areas, and we're talking about people who live in remote areas. They are, this is exacerbated, as I've said, by other factors, such as membership in an Aboriginal community, most often remoteness. Age. People lose their driving license, but they're still living in a small place where there's not a lot of opportunity to very poor transportation. And so they have difficulty making contact with the services that they need. So what are the implications? That's just some examples. Disability is a real issue if people are not close by services, and again, low income itself. So what are the implications or consequences of geographic location? Unequal access to timely and accessible legal services. Some of you may be familiar with this, but if you look at the judicial regions in Ontario, the Northwest, for example, has 48% of Ontario's land mass with 2% of the population. And that means there are 0.5 persons every square kilometer. And compared to Toronto, which of course is the tightest area. So the question really is what services are provided in these communities. And in the Northwest, for example, there's 5 court sites for that. 5 main court sites for 48,000, for 48% of the whole landmass, whereas in Toronto there are 11 court sites. 37 satellite sites, which are partial sites that rely on the main court site, and 25 fly-in courts with all the problems that flying into a location carries with them. So those are the sorts of, it's unequal access to lawyers, paralegals, other service providers, legal clinics, which do exist in the North, but have differences, vast differences between them. And they're less likely also, and this is something I haven't touched on yet, but it is something that needs to be considered. Legal problems aren't just legal problems. They're also problems that are associated with health, with unemployment, with access to social benefits, to all kinds of other things. And we find that people with, well, literacy is applicable here too, but obviously these other services are not close by either for many people living in these other kinds of communities. So again, what's the response? Pretty much technology people think of as the answer. In this case, we don't have technology that necessarily is accessible in, we don't have high-speed internet in the North, for example. So we don't have equal access to internet. That's something that is going to change. We also do have traveling court parties. Members of the court travel to different areas of the city, of the province. So those are just some examples with those two categories of problems. What's access to justice? I'm just going to define this very broadly for our purposes. Access to legal services, adjudication, the relationship to other services I just mentioned that affect legal justice. In terms of the measures I'm going to talk about, I'm really looking at access to legal services, but we shouldn't think of that as access to justice fully. And also, how does access to justice accord with substantive equality? And that's really what's underlying this notion of inclusivity. One thing I will say, and I discuss this a bit more in the paper, is it's not realistic to think that all this is going to happen quickly or all at once. And so there is a principle called progressive realization, which we've referred to in some of our reports, which is an international concept for being able to identify the end goal and understanding what's being done and identifying the gap so that people have to say, we're not doing what we aren't doing to reach the end goal. Now, inclusivity as a measure of access to justice. Why should it be? I mean, my arguments are based on the rule of law and the fact that people need to be able to access law if we're going to have a proper understanding, a proper realization of the rule of law. And that isn't just whether or not we have no one benefiting more because they're rich or whatever. It's also whether or not people are not disadvantaged by other kinds of barriers. The notion of social citizenship, which is increasing recognition of people's right to participate fully in the society. And you can talk about, for example, the most recent developments in relation to sexual orientation. And in the last decade or less, in fact, a real expansion of the notion of social citizenship to, on the basis of sexual orientation, which wasn't recognized before, is just an example. And there are other normative or theoretical reasons for doing it. But there's also very practical reasons for thinking of inclusivity, and that is the system works better when everyone can use the system effectively. That's one reason. When judges don't have to take the time to explain the system to people who are in the courtroom, that kind of thing. And it's good for society as a whole, in part because of the relationship of the legal system to all these other services and rights that people should have access to. If people are homeless because they can't deal with the fact they've been evicted because they haven't got the skills to do that, that isn't good for society either. So it can be costly in a financial sense, but it can also be costly in how we think about ourselves as a society. So those are the reasons that I'm arguing. Inclusivity should be an actual measure, explicit measure of access to justice. Now, what are the difficulties of measuring access to justice in this way? It's very hard to actually collect data that are relevant to this. Information tends to come from very many different sources, and it's not always easy to check out. It often is anecdotal. We talk about websites and who's using them, but that's really hard to measure. It comes indirectly by how people find out information or whatever. And it's important to use measures together, or we might be attributing success to the wrong thing, or we might not be picking up what is really wrong. And I talk a bit about that in the paper. And it's important to use a criterion that actually measures what is trying to be achieved. So one example is that I talk about a bit, are hotlines. There was a study of hotlines done in Australia and some in the United States as well. And what is a hotline useful for? What is that actually trying to achieve? one of the things they didn't realize about hotlines is that people tended to gain some kind of confidence from talking to somebody and having their problem recognized as a legitimate problem. That tended not to be acknowledged as a reason or a benefit of the hotlines, so that wasn't being picked up. On the other hand, a lot of people couldn't take what was being told them, the instructions they were given, and take the next step. So then the hotline was a failure. So what are you trying to achieve? Where are the real flaws, and how can you minimize those flaws? And that's something that has to be done with each measure. I'm not going to talk about any of the examples I've given. I gave some examples of the Legal Services Board in the UK and some measures they're using. There's a new Justice Index in the United States that's looking at access to the courts, and I've built on some of what they talk about, including access for people with limited English proficiency, with disabilities and gender, race, and ethnicity. They tend on that last, disabilities, race, with race, gender, and ethnicity, to think about it more, are there barriers as opposed to what are needs, but really they look at a lot of the same issues. The last point I'll make about measuring, using measures, is that you have to use measures that reflect what you want the system to be. So I don't know how many of you are familiar with changes that have occurred in the UK to the legal system and the provision of legal services. But as a result of a major report that was done there, it is now possible to deliver services through what is effectively a business corporation. Not LLP, not a law firm that operates as if it's effectively a business corporation, but actual business corporations. And they deliver services in different places, so you can actually get legal services in a supermarket, and why not? You can get mortgage services in a supermarket, so why not legal services? But it is a different vision of what legal services are really about. It's a much more commercial view of how you provide legal services. So the way you measure that is going to be different from thinking about it as a particular sort of social service or something that is really the delivery of the rule of law. So that's something that we have to keep in mind. What are we trying to measure, in fact? How do we view the legal system? What's its goal? And what needs to be done to achieve it? So, provision of legal services, which is what I'm using for my measure. You need general information, you know, how many lawyers, how many legal aid lawyers, where are they located, et cetera, paralegals. And there has been a study of this done by the Ontario Legal Needs, access to civil justice, and there is a volume on geographic access. So some of that work has been done and explains where lawyers are located. And what they found isn't always what you might expect. But that enables us a little more easily to see who has access to lawyers easily and who has difficulty on geographic basis at least. We need to know what other kinds of in-person assistance are available. So if we assume that people cannot read materials on their own, where can they go to get help to do that? Well, they might turn to a family member, but the family member isn't likely to be able to help them at a certain level. So we need to talk about community centers or whatever it might be that can provide that kind of assistance. We talk about that quite a bit in our family law report and the need to provide that in-person assistance. And that in-person assistance has to be responsive to the kinds of characteristics that you're looking at and circumstances. And finally, you have to involve people themselves in figuring out where are the problems and what is needed to overcome those problems. So that's a question of people being involved in the law reform process and the redesigning of the system. And some of those studies in other jurisdictions have actually talked about that. And then how do you incorporate the viewpoints into the reforms? You have to ask questions about how are you doing your consultations, how are you overcoming barriers to people participating in those consultations. This is something we've looked at the Law Commission. So it isn't always the obvious, it's also things like childcare, preventing people from actually going to a consultation. So how do you deal with that? Provide childcare. You know, just questions of transportation and things like that. So then the question becomes how to use the results. And I can talk more about those measures. I'll finish this and then you can ask questions, and if you want some more detail, we can go into a bit more detail on those measures, how we might actually ask the questions. How to use the results, how to apply what we've found to how we deliver legal services. So what kind of indication do we have of the need for other assistance, in-person assistance, which may not be legal assistance, but other kinds of assistance? I gave and being aware that sometimes when you provide assistance, it turns out to be a disadvantage for somebody else. So I gave the curb cut, the little ramp on the sidewalk, as an example, which seems like a great example. And one day I was out with my dad, who has macular degeneration and can't see and has a white cane, and we were going down to cross the street, and he panics when he gets to those curb cuts. He can't see them. And putting his cane out, you know, he may not be as skilled as he might be. He's not always used a cane. He's 91 years old. He finds that a bit of a panicky experience. And in fact, I then started reading about how this isn't so uncommon. And that so for certain people, those curb cuts pose their own sort of challenge. Not that a curb is so helpful, but they're not a panacea necessarily. So we have to be conscious of the unintended consequences of these things we put in place. Okay. Identify where responses are still required. As I said, we might be able to come up with great thoughts, but there might and ideas and implement them, but it's not going to cover everybody, so what else do we need to do? Now, I'll just touch very briefly, but when I wrote this, I hadn't thought about this as much, but this is part of the paper I'm giving. I'm going to include more of this in the paper in Vancouver, but let's look at what the implications of what I've been talking about might be for delivery of services and legal services in different ways. So you have full-time, you know, full representation by a lawyer who's there when you need that person, if you can pay for it. You have a legal aid possibility of somebody who has an ongoing relationship, let's say first, with your case, but you know, first of all, it's hard to get, and second, will have limited ability to be there when you need the person. Or you may have pro bono services, which is that there's a lawyer who, for whatever reason, is prepared to give time free of charge. May not actually work in that area. May not always be available, and shall we be blunt, may be doing it because it's a good marketing tool as well as having great altruistic values that make them want to help other people. Now, on top of that, we have, and I mentioned the lawyer providing full representation, but of course we also have now something the Law Society has recognized as a perfectly okay way to provide services, but which had been provided this way before: unbundled legal services or limited retainers. So, you know, you go to a lawyer because you need an initial advice. So that lawyer is, of course, very careful in telling you that that's all they're giving you and you shouldn't be relying on them for anything else and so forth. And you tell your problem to that lawyer and they give you your initial advice. And that also sounds good, you know. If you can't get full representation, then Well, getting some may be better than not. And for certain matters, you also have paralegals, but they can't provide all kinds of legal help. So when you have the limited retainer, comes later and you realize you need more help, do you go to that lawyer? Maybe. You might go to somebody else. Legal aid provides limited retainer services. That's built into legal aid for certain purposes and has been going on for some time. Okay, think about what I said about these characteristics of literacy and geographic location mixed in with some of these other characteristics. What kind of impact do those characteristics have for delivering those sorts of services? Pro bono, given what pro bono is, limited retainers, legal aid with their limited capacity. Since many of the people that are covered by this will be people who actually cannot afford to go to a lawyer, and certainly can't afford to go to a lawyer who will give them as much time as they need and to represent them as fully as is needed. So let's assume it will always be, for most people in these categories of people, less than full representation. So what kinds of characteristics seem relevant to that? You just throw out ideas. You do think of something, don't you? You're looking like you do.
To be honest, I don't really understand the question.
Oh, okay. Then you should say that. Okay. That's great. That's as good as giving an answer, because everyone's sitting here saying, what is she talking about? Okay. And that's what a lot of people won't ask, whether or not they're law students or whether or not they're in a courtroom and somebody's saying something they don't know. So how do we proceed from that? Okay. So I've talked about some of the difficulties people who have low literacy skills have. Understanding other people, explaining what they need, being able to take instructions away and follow up with them, etc. Okay. I've talked about geographic location and the difficulty of access to services and the impact, whether or not it's legal or other kinds of services, and the relationship. So not easy access to legal services, not easy access necessarily to finding information online. In both these cases, probably, depending, you might have, with the geographic location in particular, people living in remote Aboriginal communities. So those are just some of the factors I talked about. So think about those factors and think about how legal services are delivered by lawyers doing legal aid, lawyers who are pro bono, and lawyers who are providing services on a limited retainer. So it's a specific service they're providing, and that's all they're providing. What kinds of things might be relevant to the relationship for somebody, or the difficulties for somebody with low literacy, or somebody living in a remote community, in thinking about the value of those services? You don't get to answer the question. Not yet. Yes.
Well, insofar as you said...
Oh, you need sorry, it's my fault. I interrupted the flow of this. Thank you. Yeah, just start.
Yeah,
fine.
Insofar as you said economics influence a lot of these things across the board, a lot of people tend to live kind of in the tyranny of the moment. They have their own needs to meet. Their legal problems might be across a large span of access. So they might not understand that they are able to access a landlord-tenant board. That might have exacerbated a criminal issue for them. Like, there's a lot of problems that are
Okay, that's right.
larger, I think. But
Okay, that's right, and that's something that has been studied and shown to be the case. So what follows from that when you are getting service from somebody who is providing it on a limited retainer? Pardon? Oh yeah, you need the mic.
Just working off of the multiplicity of potential legal problems. I mean, if you're working off a limited retainer, you're going to have to prioritize about what you want to have to deal with. And you may not recognize necessarily what is a priority, because the way you see it may be different than, for example, the legal priorities or the priorities that, or the effects it'll have on your life.
That's one consequence of that. What else?
Yeah, good afternoon, Dr. Hughes. My name is Edgar. I just wanted to know that, have you done any studies in terms of in the Nordic countries? Because in every other social aspect, Sweden, Finland, they outpaced Canada and outperformed Canada in many economic and socioeconomic areas and health areas. Right. So I just want to know if you've done any, because I haven't really studied or explored that aspect with the data, so I don't want to comment and speculate. But if you have, would you comment and share your knowledge in terms of?
I haven't actually looked at those. Most of the studies that you come across tend to be in Australia, the UK, New Zealand, that kind of thing.
Okay, because when she raised the economic issues, I know in those countries, irrespective of economics, they've provided tremendous equity and parity. So I didn't know about how the legal issues were in that regard, but thank you.
Right.
Yeah.
Well, we looked at, I should say that we looked at one or two other systems in our family law project, which raised a lot of these concerns as well. And we had actually somebody working on that project who had come from the Netherlands, so he included a lot about the Netherlands in there. And it's got a different system, so that there's what's called a counter system, and so it deals with all kinds of legal problems, and people go and can identify their problems at the same time. But I'm not familiar with the Nordic countries, actually, although you raise it, it's a good point, because it is, and maybe partly because they're so different in other ways that it makes it harder to compare. Not bad to look and see if there is something. Yeah. Maybe it's easier for me to carry it here. Okay. Or we could all join in one table. Okay.
Thank you, and thank you for your talk. I'm sure that the sorts of difficulties that you're discussing today about indigent or illiterate citizens and the law are often, issues that the medical community experiences as well, and how to get people to be informed or engaged, or how to recognize what issues are and how to engage in it. And again, I'm not sure how successful the medical community has been in addressing these topics, but I think I'm sure there's ways of learning from one another, and ways in which you can engage the community in a sensitive approach. I mentioned medicine, but I'm sure there's other issues too, like education for children, medicine, these sorts of things. I think they would benefit from having, discussing shared experiences and difficulties.
Right, I think that's right. We, in our family project, we actually looked at the medical model for setting up multidisciplinary don't need that. Multidisciplinary clinics. Although in the medical community, multidisciplinary means different medical disciplines. So it doesn't mean bringing together, a legal worker and a social worker or something like that, or a psychologist would be included, but that kind of thing. But the idea that you need to look at all kinds of different disciplines at the same time is certainly something so that's one way we looked at it. And I think in terms of the ability to address many of these issues, from what, I see some work on that, but there are still quite a few problems with it. I mentioned translation, for example. well, you may know the Eldridge case, I should hope by now. So in Eldridge, at least constitutionally, people in hospitals are entitled to an interpreter as part of health provision. So, but in practice, how likely is that? So I don't know the answer, how likely it is. I'm not asking because I don't think it is likely. And that's important. I mean, I remember myself once was in the hospital and there was a woman who spoke Greek, and only Greek, and she had some difficulties, which I kind of figured out from the doctors because, they don't care who's listening. Who was her interpreter? Her son. And that kind of got me. I thought, especially given her problems, I thought this was so inappropriate. But there was nobody who could be a translator. That was a long time ago. And I think there's been a lot of change there. So there's been sort of a recognition there. I think we face some of the same problems, though, in terms of providing those extra services to people, right? One of the limitations of the medical model that we found is because the health system is so different, because it is a social system, because it's semi-public, semi-private, semi-public, whereas the legal system is only, partially public, very limited in that sense, and is considered to be primarily a private system. So it's harder to build these things in. But I shouldn't, you also get in the legal system, ties with other bodies. So you may have a legal aid clinic that's got ties with a community center. And the community center might actually have links with others as well, including people in the medical communities. So you get quite a mix then. So what you're raising, I think, is really important. Let me ask you this question then, if I have to, I'll come to so. Let's think about what it's like not to be able to read well or to understand exactly what someone's telling you. That you are really uncomfortable with talking to the legal person in the first place. You don't really know how to express what the problem is. So you go to somebody on a limited retainer, let's say, and explain it. Or you happen to be able to get legal aid for that purpose and you explain it. But then you go to see somebody else because you need help later on and you have this particular difficulty of explaining yourself. It goes back to your priorities, right? You raise priorities. You have difficulty explaining yourself. You didn't really understand what was going on in the first place. You have difficulty going off and doing what you're told to do. Just think how much harder that is when you're dealing with different people than one person who actually understands what your difficulties are and has learned to adapt to them. So we talk about training lawyers, and we talk about training legal aid lawyers, and we talk about training judges, and we talk about training, lawyers who are going to work in a particular community. So they, for example, working with persons with disabilities, they learn about that and what you need to do. But let's take a pro bono lawyer who might actually be at McCarthy's, but they're good-hearted, let's say, for the sake of it. They're good-hearted, because many are, and many of you maybe. So they want to help people. But that's not what they do. They are giving something to other people, but it's only going to be for a particular purpose. How much training have they had to deal with this? And it's not going to be that everybody in the legal system is going to do this. The question is, what links can you make with other community organizations that do learn how to do this and can assist the process? But in order to understand what the implications are, you have to think, what are the characteristics of the person and what are the characteristics of that service? and make the link, and do they match up? And unless, you know, that helps us understand where the real gaps are in the provision of service on the basis of inclusivity. And that's what we haven't really done that well to date. We talk, for example, about the need for people to work with people in particular cultural communities, for example. And there are community centers that can help with that. So we talk about that, but we don't necessarily link it specifically with how other legal services are provided.
I guess my question is that we talk a lot at this school about access to justice and in terms of inclusivity and in terms of who that person is talking to in that interview, but we don't talk about who's excluded from this place, from this institution, and the fact that access is only becoming tighter at the financial end of that, and the notion that we have to provide legal services to underserviced communities in underfunded programs, like in it admittedly, but also that we make this a financially crippling process so that, like, we don't, it's not acknowledged that it's exclusive, that there's no inclusivity really in this place. There's very little done to ameliorate that. And what effects does that have?
Let's comment there on that point, I gather. Oh, okay.
It's just to build on the comment that you made.
Okay.
I've always wondered why there isn't a mandatory education about at least general areas of law as people go through the only mandatory part of education, which is high school. Because, I mean, I think that could at least help with identifying whether you can access the law, where to look for, like all those basic things. And the rules of the game, which if you think of life as a game, just aren't taught. And I mean, that kind of ties in with the exclusivity, and that's the exclusivity to knowledge.
Yeah, you know, this came up the other day. I was surprised, actually, to learn that there isn't anything in high school. I was under this misapprehension that there was some kind of, I don't know what it would be called, but, you know, civic course or something that kind of introduced you to some basics. Now, there are some programs that go into the schools, including, I think, maybe something from Osgood. There are students who go into high schools, right? And I know that the Civil Liberties Association has a particular education piece that is related to high schools. And then there is OGEN, which is a community clinic which also delivers information to high school students. But a systematic way of including this, which is what you're talking about, is and I would just echo, I'm not sure why that isn't the case. I mean, whether or not it's, I mean, you can do some basic stuff to introduce people to basic information, to get an understanding. You know, when I started teaching law, it was at New Brunswick, and we decided to do an orientation week, and this was, you know, everybody was starting these orientation weeks, and so we decided it would be basic. I mean, some people go into law and they already know something about it. Their family members were in law or whatever, and increasingly, in fact, you know, people have not had that kind of background. I'm going to come to your question in a minute. But the thing that surprised us is the people who didn't know how government was set up. And these weren't people who had come from other countries that didn't have the same system of government, you know, on the national accreditation, because New Brunswick used to have students who were doing the national accreditation program, and so they'd come and take several courses, and they might come from, God knows, you know, anywhere really, including civil law countries. It wasn't that. It was people who had gone through the Canadian school system, and they didn't know how the system was set up. And we had to include that as a kind of remedial introduction to the system. And that, I thought, my God, you know, if they don't know this. What else don't they know? So I'm not sure why that's done, and there may be others who have a closer connection to the school system, because I can tell you I have none. And why that wouldn't be part of it. There's a comment here.
Yeah, just a quick follow-up to what you were saying. I think, you know, I would like York University, Osgood. Yeah, sorry about that. I would like York University and Osgood in particular to really communicate the importance of the civic justice and the law, because not just high school, I think junior high, I would say, because you learn about the national anthem and civic responsibilities, because children's rights are being abused even in Canada, and it's a universal human right that has to be protected and safeguarded consistently. And I think it's something that's really important to me. But I'm also surprised that when we talk, I studied the socioeconomic aspect when I look at health informatics and health policy, is that many middle-class families are on the brink like this of debt. They have a home and they live in a middle-class existence, but many of them who are university educated, sometimes even professionals, doctors, can't read the legalese. They're tremendous PhDs, but they can't read the legal language. And a gentleman said, "Edgar, do you understand this?" I said, "Yeah, I can, but I don't even have a degree yet. You're a PhD." And he's like, I just don't understand some of the language. And it's tremendous that many people don't, it's not about being low literacy levels, but it's about comprehension. They can't read what's in front of them. And people who are not even with PhDs, but I'm familiar with people who are just hardworking, whether they're firefighters or whatever, they're a paycheck away. They're living in a nice home, in a nice community, maybe in Richmond Hill, but don't be fooled. When you look at the debt situation right now, the global situation, people are in trouble, and I don't think we're appreciated. They don't know where to go. They don't know, and they're ashamed because the image that they have to maintain, and it's hurting, and everyone is hurting. And it's not, when he talked about race, and it allowed me to step back and said, you know what, people who are, race is important, but a lot of things supersede that right now, and we are tied together, the threads that bind us, that humanity, that we have to come back and understand, that universal understanding to the core about all of us being attached will transcend the race issue, but with respect, because for me respect is regarded with utmost seriousness, but understand that that action and that activity needs to take precedence. And I'm so afraid for Canadians who are middle class, who are striving to get into the upper class, and if I have that fear for them, just imagine people who are poor. Mm-hmm. So I just think it needs to be something that's discussed openly and across the socioeconomic backgrounds, and in academia especially, because academia has the power to be they do need funding, but we can sort of fight undue influence of the self-interest of the government, who have their own agenda, or they want to compromise the integrity or the scholastic or informational integrity of research and information. And I think we as students here, both undergrad, grad and post-grad, and people who are doing PhD candidates, and even the professors, have tremendous power to know that your role is more than just being a student or a civic servant. You can be a transformative presence. So I just want everyone here, including yourself, to recognize that.
Sure, absolutely.
Just to build on the last question about, I guess, the legalese. I mean, I do research in tax law, and even tax lawyers don't really understand what tax law is.
It's designed that way, isn't it?
I'm just wondering, the considerations that you have looked at. I know that, for example, New York has a great system where they require, in order for you to continue to be a member of the bar, you have to give a percentage of your billable hours in pro bono work.
Right.
That would provide high-quality services.
Right.
From people who practice in that area of law to people who would otherwise not be able to afford it. And also would expose them to the problems of people who they would not normally deal with. Is that being considered?
It gets considered from time to time that there be some kind of requirement of that. And
just not a very serious consideration.
Well, I think, people sort of say, well, what is pro bono? What is giving? Is it sort of something you do because you want to do it, or you're forced to do it? And there's different ways in which people try to encourage people to do it as opposed to making it mandatory, right? Which is a carrot instead of a stick. So I know when I was in Alberta that I was a Dean of Law at the University of Calgary, and I was an honorary bencher because of that, so I listened to all the bencher discussions, which were illuminating. But one of the things they really looked at was this question of pro bono services and allowing, trying to get people to do more pro bono services and to allow it to count for different things. The other thing that comes out of it when you start looking at what pro bono services are defined as, and people fall into this, pro bono turns out to also mean sitting on a corporate board. So that can satisfy it. It can be, and I don't say this is a bad thing, but what I'm going to say now, I'm not saying that's a bad thing either, but I don't think that's really what you're thinking about. No. Or, for example, coaching your kid's Little League team. Well, good you do it, but, and maybe it's good people, no lawyers are prepared to do that, but it's hardly what we think of when we're talking about pro bono. So I think part of the difficulty is it's really actually difficult. There is a real split, and some of the things that many of you have said here suggest you wouldn't fall into this, some of you may. A real split on whether the profession should remedy the deficiencies of the system. To expect lawyers to do pro bono. And I'll give you sort of, and this goes to the question I actually asked, which is, and I'm happy to hear these views. I mean, I think ultimately they're deeper than the questions I'm asking, but that's fine. When you're looking at the way services are delivered, and the question is, say, pro bono, which is becoming more and more popular. I mean, it used to be people really did take unusual cases, and there were people who really just wanted to help. And now we have a systematized pro bono way of doing, an organization that actually does this in a systemized way. And that may sound good, because then you organize it, you try to link people who know something about the area and all that. But you know what? It's because we don't provide adequate legal services to people. We don't, whether you think about legal aid, which is woefully underfunded, everyone agrees with that. We do not provide adequate legal services in a system that is recognized as a consistent, knowledgeable part of the delivery of legal services. Instead, we say, okay, people who are prepared to go out there and spend a few hours a week or whatever, a month or whatever it is, whether or not it's really their area, or whatever. I mean, you talk about tax, and there would be tax problems that people without much income need, for sure. But most of the people doing tax aren't dealing with that, right? I mean, you got HR block for that, right? H&R block. I mean, is the way they might see it. So, do you want to have a system that is built on volunteers? Do you want to say volunteering is an acceptable and equivalent way to providing legal services? I think there's a problem with that. Not everybody thinks so, for sure, and I know among many people I know this is a minority view. I have real concerns about it because people may intend well, they may be very skilled in what they do, but that's not how they earn their living, actually. They earn their living in many other ways, and the idea that some people are going to have pro bono and some people are not. Some people at least get legal aid, even if they can't afford, who gets the pro bono? Services where there's, not the same kind of regularity with them. So I have some trouble with pro bono, actually, for that reason. But, it's like limited retainers, I will say. I've had real problems with limited retainers. I think there's all kinds of problems with limited retainers. You talk about PhDs not understanding legal. Look at an area that you haven't learned and see if you understand it. Most of us wouldn't represent ourselves in an area, well, I would never represent myself, but, you know, for all kinds of reasons. But if you can sort of make some sense out of some things, but you can't out of others. It doesn't matter what level of education, you can't necessarily understand it. But we're talking about people who are they couldn't understand almost anything, never mind the legal. It just makes it that much worse. So, you know, what are we providing people? So limited retainers to me are a real problem because, first of all, people don't often know what their legal problem is, right? They don't know if they have a real legal problem. They don't know how to define it. They don't know what it really looks like. They don't know what they need to do with it. I don't say that's everybody, but there's a lot of people in that. They tell their stories with a whole lot of other information. If they're talking to more than one person, do you think they're going to go and tell the next person exactly what it is? No, we're going to go through that again. Or people who are troubled, I mean, by the nature of their problem and are embarrassed to talk about it, then they have to go and talk about it to somebody else. So many areas of law that we talk about require trust with the legal advisor, whether it's violence against women, whatever it might be, right? You need to develop trust because people don't have trust in the system. So you sort of get trust, but then you're off to somebody else. And you got to develop trust again. But I realize that there is not a way in which everyone is going to have the kind of legal representation that we all may think is perfect, which isn't necessarily the form it takes now, but something. And it is going to be limited retainers, and it is going to be, you know, pro bono. So how do you maximize the benefits of that? I don't know, minimize the disadvantages. So I think there's real problems. So to sort of promote it even more, I don't know. It's sort of like you make continuing legal education mandatory. How do people meet that? You know? Some of it may be they're really learning something. Do you think that's always the case? So how do people meet mandatory requirements? Different ways. It's not a guarantee, I guess, is all I'm saying. That's just my view, though, because other people would agree with you for sure. Yeah.
So the question I have is, if I am hiring a lawyer, for example, and I'm paying the lawyer, there are some rights that come with that. I can hold the lawyer responsible.
Yes.
For the quality of service that is rendered.
Right.
I don't know if the same is applicable to where the lawyer is providing the service pro bono, or
right.
Whether the same rules governing the rights are present there.
I think one of the advantages, actually, of sort of a more organized pro bono system is bringing more and more of that sort of thing to bear, because certainly once a lawyer takes you on, whether you're paying them or not, I mean, there's a relationship, and all of that follows. But both pro bono and limited retainers do have some other difficulties, I think, which is continuity and service. You know, how do you transfer files when it's all the time? You know, maybe it's okay if it's always the same lawyer you're going back to, you know, but if you're not, how do you transfer the files? How do you ensure that one of the lawyers isn't missing something crucial? Because after all, this person, the client, told the first lawyer and thinks it's all settled. Right? That second lawyer doesn't know anything about that. So you're raising some issues, you know, it's not quite the issue you raised, but it's a reflection of some of those other problems, that figuring out how you can make those relationships equivalent to what we expect. And there have been problems with that. I mean, the Law Society, now that it's made limited retainers a legitimate way to deliver services other than if it's legal aid, which has had it already, and they have it's an internal system after all. But ordinary lawyers doing limited retainers, they now include in the training for the bar, they include information about limited retainers and what's required. But historically, there's been more malpractice with limited retainers than not. And not than not, but in other areas, because they raise such these kinds of problems that it almost puts more of an onus on the client. But it's hard for a lawyer. A lawyer has to be really careful about, you know, what they're looking at, that they've carefully defined what the limitation is. What is the retainer exactly? I mean, lawyers do that generally, but this has got to be very specific. So your question is a reflection of that, and there's an attempt to try to train lawyers to understand the same things have to apply, and to build into training understanding that, and to make it more organized so that you have some of these things dealt with.
And wouldn't that require intervention from someone who is not the client? Because if the client is uneducated, probably does not know the quality of service that's being delivered.
Yes. That's always true, though, right? Most clients don't have the faintest idea whether their lawyer's doing a good job, win or lose. I mean, if you don't know, how do you know? Right? I mean, it's the same thing with not being able to read the law. I mean, people don't. And this is, I find, an incredible thing that we expect people. We say it takes 3 years to become a lawyer. Then you should learn a bit more, you know, and then you should be practicing. Except we expect people who have absolutely no idea to go out and represent themselves with some minimum kind of. So, I mean, that's an interesting question about what we really think of legal expertise or what we kind of expect from other people. And so we have all kinds of ways of trying to respond to that, and you know, some of it, you know, there are effective ways to offset some of that and not others. One question, how far should a judge intervene? And there's an assumption judges will intervene to some extent to help an unrepresented litigant, but imagine being on the other side, paying a lawyer, and then the other person's getting help from a judge. It won't be what it looks like to that person, but perception is important, so there's those sorts of problems too. I really think a lot of the answer, and some of the answer to what I've been talking about, is actually to look outside the system for people to help, you know, who can answer a lot of these questions, and to get enough training that they can then be intermediaries between. And there's some of that, you know. One legal aid clinic, for example, is located very close to SALCO, one of the South Asian legal clinics, and so they can work together with that population, which is really important. And I think that's really a good development. Sue, you were going to say something?
Oh, it's been...
it's gone.
No, the ideas have been all discussed.
Anyway, so you've raised some much more fundamental questions and your question, believe me, is an ongoing one about who's getting legal education. You won't believe me when I tell you more people are getting it. More people who couldn't afford it before are getting it now. It may not seem that way, but if you look back and you realize that it's a more open system, if you could go and look at the pictures on the wall, not just because it's men, women, or people from different communities, but you can get a sense of who's in those pictures, right? Is it, there is more aid for students than there used to be. But there's all kinds of barriers that apply to some extent to what I'm talking about, which is that people are afraid of the legal system in a way, or to think that they can be part of the law school, or there's an image that has to be overcome as well, and that's true of the system and of legal education. But so you are all going to be out there when you graduate, doing all the things that are going to change the system.
Ideally.
ideally. I will also tell you that Osgood is one of the law schools that has a reputation for being more accessible and for teaching more in this area. That's why I came to Osgood, because of that. When? 92, 2000, oh God. What is it, 40 years ago? No, 30 years ago. And even then it was more than the other schools, and some of the others have caught up a little bit with it. But you know, it's true. The questions you're raising are valid questions. They're different. It's moved along, believe it or not, but it doesn't mean it's where you want it to be. And that's where the work continues to be done.
I just want to add one quick point.
Thank you.
Yeah, I just want to add one quick point that the need for balance, I think all existing law students and all future law students should be mindful of the importance of balance. We should
be
mindful of the importance of balance.
Balance,
economic balance, career, professional balance, professional development, but also of our health. I mean, it makes no sense trying to work 100 hours a week, and if you're developing a relationship with a life partner, whether it's a woman or a man or a same-sex couple, you're not at home. Or are you gonna like live at the office 24/7? I understand the need for money and to acquire these material things, but the importance of balancing it and not be burnt out in like a year or two. And you're going to lose your relationship. You're going to lose, perhaps alienate your family, some of your professional colleagues, rather than even progressing. Say you get partner, but at what cost, what price? We have to factor these things in too, I think, before, during law school, and even after, because life is unending learning, and that's growth. So I think it's not something that's unique, and you think it's like achievement. I heard Donald Trump say achievement is not a plateau. Achievers keep moving all the time because we keep achieving, we keep doing.
Donald Trump.
Yeah, so, I know a lot of...
Somehow, suddenly, everything else you've said.
Yeah. But it's just you can take wisdom from
Yes, you can take wisdom from a lot of
Yeah, I just think that was something that was very useful. That it could be applied. So for sure.
Yep. Good closing comments. So thank you very much. Thanks for your contributions. And good luck in doing all this.